Your neighbor's fence has sat 2 feet onto your property for 20 years. You didn't complain, you didn't hire a surveyor. And now, under the law of every single U.S. state, your neighbor has a legal claim to that strip that a court could enforce. Not because he stole it, because you let him treat it as his own for long enough that the courts may no longer care what your deed says. It's called adverse possession. And if you own a home, it's one of the most expensive things you probably haven't heard of. The logic dates back centuries to English common law, and it exists in every state in some form. The idea is deceptively simple. Land that sits idle or unclaimed while someone else visibly uses it should eventually belong to the person using it in practice. Courts call it settling uncertain boundaries. Lawyers call it sleeping on your rights. But here's the part that should make every homeowner pause. You don't have to know your neighbor is encroaching. Your silence, your failure to object, to send a certified letter, to mark your line, is often exactly what starts the legal clock. And that clock runs anywhere from 3 years to 30, depending on your state. The fence doesn't have to be malicious. It can be a mistake, and that mistake can become your new property line. There's also a related doctrine called boundary by acquiescence, technically distinct because it doesn't always require proving hostile intent, but for homeowners, the result is identical. The fence line can override the deed. American property law at its most efficient. In 2006, a family in Washington state built a fence where they believed their property line sat. They mowed up to it, planted a memorial tree, even buried pets on what they thought was their land. For nearly 2 decades, no one seemed to question it. Then a developer bought the neighboring lot, commissioned a survey, and discovered the fence was wrong. The developer bulldozed the fence, the tree, and the pet cemetery. The family sued. And in 2026, the Washington Court of Appeals ruled the family had already won legal title to that land years earlier through adverse possession. The court found that every previous owner of the neighboring parcel knew the family had been possessing the land up to the fence line. A change in ownership does not reset the clock. The developer bought a lawsuit he didn't know existed. But that wasn't even the most extreme example. In rural Texas, a family paid taxes on fenced acreage since 1935. A 2020 survey using the deed's legal description found the tract totaled 599 acres. A second survey based on the existing barbed wire fence showed 642 acres inside it. That's a 42-acre discrepancy, larger than many city parks. The family had treated the fence line as their boundary for nearly a century. The court had to decide whether a wire fence beaten by decades of weather carried more weight than a paper deed. In Missouri, the Court of Appeals reached a similar conclusion in Bourbon versus Benson. A landowner had fenced and treated a wooded strip as his own for years. When the record title holders commissioned a survey and discovered the encroachment, they sued for damages. The court said no. The fenced use had been visible, continuous, and treated as ownership for long enough that the title holders should have noticed and objected. They didn't. So they lost the land. To win an adverse possession claim, a neighbor has to prove 5 elements, usually by clear and convincing evidence, which is a higher bar than ordinary civil cases. First, actual possession. They have to physically use the land the way an owner would, mowing it, fencing it, building on it. Second, open and notorious. The use has to be visible enough that a reasonably attentive owner would notice. Sneaking around at night won't cut it. Third, exclusive. The claimant, not the true owner or the public, has to be the one using it. Fourth, continuous. The use can't be interrupted for the full statutory period. And fifth, hostile, which doesn't mean angry. It means without the true owner's permission. This is where most claims die. If you ever gave your neighbor permission to put up that fence, even informally, the clock doesn't start. But silence doesn't count as withholding permission. In New York, neighbors sued to force removal of a driveway they said encroached on their land. The defendant argued that a hedgerow and chain-link fence had marked the true boundary for years. The appellate court found the party's predecessors may well have acquiesced in treating that fence as the line and sent the case back for trial. A fence can beat a deed. There's a related doctrine that makes these cases even harder to defend against. It's called boundary by acquiescence, sometimes practical location or boundary by agreement. Unlike classic adverse possession, this doctrine doesn't always require proof of hostile intent. A fence built by honest surveying error, with both neighbors simply treating it as the line for years, can be enough. Courts treat this as closer to equitable estoppel, a principle that stops someone from denying something they previously accepted, than trespass. The practical unfairness of upending a boundary both sides silently accepted outweighs the paper description. Under Oklahoma law, when adjoining owners deliberately build a fence understanding it marks the true line, that becomes a practical location that binds them and their successors, even if a later survey shows it differs from the deed. Minnesota courts draw a sharp distinction between a fence neighbors deliberately placed to mark the boundary versus one a single neighbor threw up haphazardly. Only the former supports a claim. And here's where the timeline gets brutal. Arizona can require as little as 3 years if the claimant has color of title. That's a flawed but recorded deed that appears valid. California, Nevada, and Montana require 5 years, plus payment of property taxes on the disputed strip. Most northeastern states demand 20 to 30 years. The national average sits around 13. The median minimum is 10. The median maximum is 15. But the part almost nobody knows is still coming. And now for the part that affects you directly. A new, accurate survey does not automatically fix the legal boundary. Courts have repeatedly ruled that a survey doesn't erase a boundary established by decades of acquiescence. The practical location beats the paper description. Buying title insurance won't bail you out either. Standard policies contain a survey exception that excludes coverage for encroachments, overlaps, and boundary disputes that an accurate survey would reveal. If you skipped the survey when you bought your house, that risk is yours alone. Paying property taxes on your full lot doesn't defeat a neighbor's claim in most states. Only a handful, notably California, Nevada, and Montana, require the claimant to have paid taxes on the disputed strip. In most states, your ordinary tax bill does nothing to interrupt the clock, and giving your neighbor permission defeats their future claim. But staying silent doesn't protect you. Silence is often the exact condition that lets the claim mature. You generally have to take an affirmative step. A written objection, a certified letter, a legal action. Waiting is the one thing that makes these claims winnable. So what happens when these cases reach a courtroom? The outcomes vary, but the pattern is consistent. Judges rarely reward the owner who slept on their rights. In Washington, the family kept their land. The developer learned that bulldozing a fence doesn't erase 2 decades of visible possession. In Missouri, the fenced strip stayed with the neighbor who had treated it as his own. The title holders walked away with nothing but a survey bill and a hard lesson. In Texas, the dispute over 42 acres went all the way to the state Supreme Court before resolution. Because when land has been fenced and taxed for nearly a century, courts are extremely reluctant to upend the practical boundary. The law favors stability over certainty. It favors the neighbor who acted like an owner over the owner who acted like a stranger to their own land. This is not a loophole. It is not a technicality. It is a deliberate, centuries-old choice by the legal system to reward use and punish neglect. And it means one thing for homeowners: your deed is not a guarantee. It is a starting point. The real boundary is often whatever people have treated as the boundary for the past 10, 15, or 20 years. A survey can tell you where the line should be, but adverse possession can determine where the line truly is. The fence often wins. The paper often loses. That is the verdict the legal system delivers again and again. If you own property, or plan to, this is what you do. First, get a boundary survey before you buy, and periodically after. A licensed surveyor can show you exactly where your legal line sits relative to any existing fence. This is the single most effective way to catch an encroachment while it's still easy to fix. Second, if a survey reveals your neighbor's fence is on your side, address it in writing while the clock is still running. Waiting lets these claims mature. Third, if you're comfortable letting a neighbor's fence encroach slightly, put permission in writing. A simple signed letter granting permission defeats the hostile element of any future claim, because permissive use cannot ripen into adverse possession. Fourth, consider a formal boundary line agreement. Neighbors can jointly define and record an agreed boundary with the county recorder, which fixes the line for all future owners. Fifth, watch for maintenance patterns. Courts weigh landscaping, sheds, and mowing as evidence of acquiescence. A neighbor mowing up to your fence for 15 years is building a record, whether you realize it or not. Finally, understand that title insurance likely won't help. Standard policies exclude boundary and survey matters, and the recent wave of state squatter reforms in 2025 and 2026, laws in Georgia, Florida, Texas, and elsewhere, targets unauthorized occupants of buildings, not fence line boundary disputes. Those underlying doctrines remain unchanged. Act before you sell, not after. Boundary problems can derail a closing because lenders and title companies often require resolution before anyone signs. One last thing. In 2024, an Alaska homeowner kept a strip of her neighbor's land simply by mowing it and planting a tree, because a crooked fence had sat there long enough. The court said that was enough. Look at your fence line. The gap between your deed and the ground is where property disappears. Next week, we're examining the clause in your employment contract that lets your company claim ownership of everything you create, even on your own time. You'll want to see that one. Subscribe if you haven't. The clock is always ticking. This video is for general information only and is not legal advice. If you're facing a boundary or fence line dispute, consult a real estate attorney licensed in your state.